Hey everybody, welcome back to the channel. Today we are back here at the Ninth Circuit Court of Appeals in Pasadena. I think last time we were here, we were talking about oral arguments for the Boland v. Bonta case. Today we are on the second go around for the Rhode v. Bonta case. Of course, this case was remanded back to the federal district court after the Bruin decision came out. We got another good opinion from Judge Benitez, which brings it right back up here to the Ninth Circuit. To talk us through these oral arguments today, though, we have brought on Sean Brady. He's been on the Rhode v. Bonta case from the very beginning 5 years ago. Sean, thanks for being with us today.
My pleasure.
So if you can, just for those who maybe haven't been following along, what is the Rhode v. Bonta lawsuit that we have here? What are the challenges that we have that brought us here today?
Sure. So as most people know who are firearm owners in California, California has enacted a regime to be able to acquire ammunition, and it essentially bans all avenues of acquiring ammunition except through certain licensed vendors who are present in California. And the problem with that is that it involves a background check system that is, we believe background checks on ammunition are prohibited by the Second Amendment generally, but even assuming that they were permitted, this particular background check system is so burdensome that it fails the standards set out in Bruin and violates the Second Amendment. So additionally, there are restrictions on importation of ammunition from other states, right? Sure, you can have ammo sent to an in-state vendor who can then process it and provide it to the in-state purchaser. But again, you have to go through this flawed background check system, and you can't even go out of state yourself and acquire ammunition, say in Arizona or Nevada, and cross back into the state. You would have to send ammunition to an in-state licensed vendor and then come back home, pick it up, go through this flawed background check system. So it's a heavily burdened, unique system. There's nothing else like it in the country currently, let alone in the history, which is what the Supreme Court has told us is what we look to when we're doing the Second Amendment analysis. So.
Right. Yeah. So you got a couple of challenges there. I mean, primarily you've got the background checks, which then branch off to fees and waiting periods, essentially created for people who want to purchase ammunition. Ammunition purchases happen all the time. You can find somebody who might be going in to purchase ammunition weekly, so that can be quite burdensome. You've also talked about the importation, and we actually saw some positive benefits and the demand that's actually there after Judge Benitez's second decision, when we had, I mean, it wasn't a week, it was a few days where we saw the product of this lawsuit coming to fruition for a few days when ammunition was able to be purchased from out of state. Of course, then the stay got put back on. We've talked about, some of these oral arguments and how the main arguments in the case might not be actually what's discussed in the courtroom. This is really an opportunity for the judges to address you and the opposition for questions that they might have while they're reading through our briefs. Something that I noticed came up a lot today was, at least with the opposition, was trying to classify ammunition as an ancillary right. Can you just kind of explain what an ancillary right is and why it would be important for the opposition to classify ammo that way?
Sure. So an ancillary right is something that, so for example, paper, right? When you are wanting to write something under the First Amendment, right? You have a right to express your opinions on a piece of paper, right? But the paper itself is not your speech, right? But without it, and we no longer really dealing with paper, right. Now it's computers, but that would be your right to have the ink and the paper and able to write a book, right? That would be your ancillary right to your right to expression and speech, right? So they're trying to classify it to sort of mitigate to the court to put them in a mindset of like, this isn't that big of a deal, right? So to get into the door of the Second Amendment analysis, right, it's our burden as the challengers to show that this is conduct that's protected by the Second Amendment. And so what they're essentially trying to do is downplay the burdensome, because that's while we don't really think that is the appropriate analysis, that is what previous Ninth Circuit panels and like the BNL Productions case have held, that there you have to show that there's some sort of burden beyond just it has to be a substantial burden before you even get to that analysis. That's what they're trying to do, is suggests that this is not that burdensome because it's not the firearm. But as we all know, ammunition, a firearm without ammunition is essentially worthless.
Right. Seems like it kind of tries to take away from the plain text of the Second Amendment, and not really categorize ammunition as something that would belong to that, which might make it easier or seem like it's more possible for the government to impose such a stringent regulation. Kind of the same thing. It's a classification here, but something else that was discussed a lot with our side is whether or not this should be a facial challenge or an as-applied challenge. Now, I understand that our challenge currently is a facial challenge, but can you describe to me the difference between those two and why it would be important for this challenge to be recognized by the court as a facial challenge?
Sure. So a facial challenge is something that's essentially attacking the statute on its face, as the name suggests, right? That the entire statute has to go away no matter what because it cannot be implemented in a constitutional way, right? An as-applied challenge is where you have a statute where that on its face it's not necessarily violates the Constitution, but so the example provided in the courtroom, right, was, or that Judge Bybee was suggesting would be an as-applied challenge, is a particular individual, right, goes in to get a background check and the background check system will not allow that individual to proceed, which happens under this regime, right? And that's why they're trying to figure out, well, why isn't this an as-applied challenge? And we don't think that's right because our position is everybody who has to purchase ammunition is subjected to these burdens. Even though a lot of them, most of them, do not end up having the sorts of problems that a lot of people do, the idea that there are these problems with a significant tens of thousands of people. I mean, the way I think we can envision this to sort of resolve the debate, because I think that this is a proper facial challenge. It is not an as-applied challenge because we're not worried about several different individual circumstances. We're worried about the regime's application in itself. And so, for example, if there was a voting registration regime where it prevented tens of thousands of people, 11%, which is the case here, it precluded 11% of people from even registering to vote, and half of those people never went on to miss the election, right? There's no way that would not be struck down, that regime would not be struck down on its face. They would never say that each one of those people who are precluded from voting would have to bring their own federal lawsuit and work its way up years later through the appellate court. So that's why we think it's this fundamentally is an appropriate facial challenge, and it's necessary that it is, because it wouldn't work with as-applied challenges for the very reason I just indicated. It's not reasonable to expect normal individuals to bring a federal lawsuit just because they're being precluded. And part of the problem with that, in addition, is that a big part of the problem with this regime is that people don't even know why they were rejected or if it was proper. They're just sort of left to their own devices once they're rejected and said, okay, well, you got to go figure it out, which is part of our constitutional challenge.
Right. Well, that's fair. I mean, what about like the product of a facial versus an as-applied challenge? I mean, facially, if you win that challenge, it applies to everybody. The law is struck down. As-applied challenge, if you win in these arguments, what are the results there?
Well, in a normal as-applied challenge, it only applies to that individual, right? That individual is saying, I need an injunction, I need this relief, so it only would apply to them. Now, it can be used as precedent for other people who might be in those circumstances. They could take that as-applied ruling and say, well, I'm in the same boat, and here's but
I mean, let's just say, let's role play for a second here. Let's just say theoretically, I'm an attorney on the opposite side, and I don't necessarily see the strongest argument for myself. It might be in my interest to try to convince the court that this is an as-applied challenge, because then even if even if the merits or the arguments here are successful, it's only going to be applied to the individuals who are actually plaintiffs on the lawsuit.
Sure. But they wouldn't be able to do that because we've expressly devised this as a facial challenge, so they wouldn't be able to do that. But yes, I mean, it would behoove them. But they're playing sort of the opposite side of that. They're because a facial challenge does have a higher burden. It is as they've indicated, and as we saw in Rahimi, there are significant hurdles to have a facial challenge be successful. And so that's why you saw pushback from the panel a little bit on that issue. And it is somewhat confusing in this situation, the facial as applied nature, because to be frank, the majority of people do not face the sort of significant burdens that this regime imposes on lots of people, right? I mean, it's still flawed, but most people, when you buy ammo, it is a minimally invasive process, more or less. But that's not the point here. The point is that 11% of people do not have that it go that way, and that is a significant constitutional
problem. For sure it is. Something else that came up a few times I wanted to ask you about. Footnote 9 from Bruin, and forgive me, I guess I'm not necessarily in the habit of reading footnotes like that. Maybe that's where the attorney speciality comes in. But can you describe to me what Footnote 9 in Bruin is, and how is it that is making its way into oral arguments here?
Sure. So essentially, Footnote 9 in Bruin was basically saying how that licensing regimes, right, because that's what was at issue in Bruin, was a concealed carry license regime. And the court essentially said that those types of licensing regimes are constitutionally okay. And the footnote was that said, just because they are facially okay, generally okay, doesn't mean that they can't be applied in such a burdensome manner that they become unconstitutional, right? And so they put, for example, long waiting periods or high costs, right? So in other words, if you just have a shall issue CCW regime, and you go in and you pay $10 and you're out in a day or two, that's probably going to pass constitutional muster. You're not going to have a good challenge to that. If it takes 2 years and you got to pay $10,000, that's a different animal. And that's what Footnote 9 was essentially getting at, was like, okay, we're okay with licensing regimes, but there's a catch. They have to be reasonable. And so the way that worked its way into here is we are saying that we don't believe ammunition background checks generally pass constitutional muster because they're different in kind than firearms background checks. But even if we were to concede that, we looked at Footnote 9 to say this is a burdensome, costly endeavor. And so this particular ammunition background check, even if ammunition background checks generally can be, the government has that option, they don't have the option to implement this type of one with all the wackiness that comes with.
And you're talking about a $1 fee minimal that the California legislature is trying to make $5 next year, or the $19 fee for that background check. Or storage fees when you're trying to get ammunition from out of state. You got to go through an FFL here, and they can essentially charge you whatever they want. So I guess that would definitely make sense if you're talking about adding all of those extra things. I guess final thoughts. Watching from the seats, it kind of felt. I'm also I tend to be an optimist, so maybe you can correct me here. It felt like we had 2 of the 3 judges who understood our arguments, who were kind of the sentiment that the background checks didn't make a whole lot of sense. Was that your general sense of the courtroom, and how do you see this lawsuit going forward? Any kind of time frame that you expect to see?
Well, if history is any indication on the time frame, it's probably going to be a while. I don't want to rain on everybody's parade, but I think we've seen this show before in the Ninth Circuit. It's almost expected that if we prevail at this panel level, which I have, to answer your initial question, I am optimistic about. I think that at least 2 of the judges, you never know, but it's suggested with their questioning that they get it. And not to say that Judge Bybee doesn't get it on the merits, but I think he's a little preoccupied with the facial versus as applied thing, and that might be a route he takes out. But again, you never know. But I think this is just the beginning of an unfortunately long story. It's already been how many years? 7 years or so that we've been at this in this particular case, and I think we got a couple more years to go until we see any final results.
But perhaps progression, right? Because the first go around, we did not get an opinion from the Ninth Circuit on this. So a little bit of progression there that we're looking forward to as far as an opinion is concerned. Well, Sean, I do appreciate the insight. I appreciate what you did in that courtroom. Thank you very much for taking some time with us today.
My pleasure.
Absolutely. And guys, if you like content like this, you want to keep seeing these videos, you want to keep yourself in the loop with Second Amendment litigation, legislation, and culture in this state, please be sure to like, share, and subscribe to this channel and to these videos. It's a direct way that you can contribute to lawsuits just like Rhode v. Bonta so that we can take back our constitutional rights in the state. Thanks again, guys. We'll see you on the next one.